Hello friends, in the series on the income tax cases, today we will discuss a very important issue on chapter 6 of the Income Tax Act, which talks about procedure for assessment. In the present case, a very pertinent issue was before the Honorable Karnataka High Court, and that issue was that if the assessing officer wants to use any seized material during a search proceedings, then whether in that case it is compulsorily required on the part of the assessing officer to invoke section 153C in the case of another assessee on whom the search is not made, or whether he can parallelly make the assessment under section 143 subsection 3. This issue has been taken up by the Honorable Court in the case of Principal Commissioner of Income Tax and another versus VSL Mining Company Pvt. Limited. And the date of the judgment is 28 September 2024, and the matter has been reported in 479 ITR at page number 433. In the present case, the assessment year involved was 2008-9. The assessing officer made the assessment as a regular assessment under section 143 subsection 3 on the basis of the seized material which was found in the search of some another assessee. The assessee was contesting his assessment, and there were two issues involved in the assessment of the assessee. The first was the assessee was claiming the exemption under section 10B, and secondly it was the submission of the assessee that since the assessing officer has relied upon the seized material, so the assessment should have been made under section 153C and not as regular assessment under section 143 subsection 3. When this matter was heard by the court said that there is chapter 6 in the Income Tax Act which talks about procedure for assessment, in which the sections are section 136 to section 153C. The court said that by the Finance Act 2003 and with effect from 1st June 2003, it was introduced that whenever the searched material will be used for the assessment purposes, then the assessing officer has to take the shelter of the sections, section 153, section 153A, 153B and 153C. The court said that once the searched material is relied, then in that case the special section should be used, section 153 and 153 ABC, and not the regular assessment under section 143 subsection 3. Already the tribunal has given the judgment in favor of the assessee, but the revenue took this matter to the court also, and the two issues are before the court. The first was deduction under section 10B, which was given by the Karnataka High Court in favor of the assessee, and secondly on the issue that whether the assessing officer can take cognizance of the seized material under section 143 subsection 3 without invoking section 153C. On that particular point, the court make it very clear that the assessing officer cannot take cognizance of the seized material under the regular assessment under section 143 subsection 3 without invoking the section 153C. Friends, it has been seen that in a number of cases the revenue is using the seized material under section 143 subsection 3 where there are special provisions. So the demarcation line is there. If an assessment is to be done under section 153C, that is to be done under that section and not any other section. Similarly, there are some cases where the assessment has been done under section 153C and the assessment is to be done under section 148 or vice versa. So in those cases also the ratio of this judgment applies according to me. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax and another versus VSL Mining Company Pvt. Limited, and this case is reported in 479 ITR at page number 433, and the date of the judgment is 20th September 2024. Thank you, friends.